What's going on, everyone? Welcome back to another episode of Bridging the Gap here on the Jersey First TV network. As always, you could subscribe to the Jersey First TV network on YouTube. You can check us out on jerseyfirst.org, where you could sign up for our newsletter and sign our pledge and put New Jersey first as it deserves to be. And you can get all of our content here at Bridging the Gap. You can get our content over with the Nader Narrative and with Real Talk. I'm AJ Malillo.
I'm Steven Rambolo.
And this is Bridging the Gap. I hope you all have a wonderful week. I think we have a great show for you today. And Steven, how was your week?
You know what? Since we last spoke, had a very exciting week, I would say. I know last Friday, so this was like, we're really pulling all the way back to last week. I went on a tour of Rutgers Law School, which was awesome. I am very anxiously waiting to hear back from those guys. However, all things did sound pretty promising there. I know we have a mutual connection, and it was nice to reconnect there. So, looking forward to that very, very much. Would be an awesome and amazing place for me to sort of take the step into my 1L year uh, and continue like the riding trend of just being a product of New Jersey public schools. Jersey, like running through my veins. All of the neurons in my brain that hold information are just as Jersey as it gets. So very much looking forward to that. And then Saturday, I went and had an interview, and I'm going to be getting a new job, which is very exciting. So for those of you that don't know, right now I've been kind of like floating, doing my own little thing here, making some money, working in a kitchen with some really amazing people. And then I'm now going to kind of switch over, and I have a passion for cooking, it appears. Confectionery arts is how I'm going to dress that up. I,
That's
really
the
love ice
resume.
cream.
Those are the resume terms.
Yeah, the resume words, confectionery arts. But I made ice cream for a really long time, like high production, good quality ice cream. Certainly a technical skill, I would say. So I, did that for a while, took a step back, got some time in a hot kitchen, and now I'm going to be making my return. I'm going to go work at a candy shop and be a GM for this organization and learn how to make awesome Belgian chocolates and fun little candies. And I'm really looking forward to adding to, I'm not going to call it my professional resume. It's kind of like my fun resume, like cool things that I can do. So we're going to add chocolatiering to that.
A
And I could,
chocolatier Steve. I like that.
yeah, I feel like Willy Wonka now. Like, do ice cream, I can do chocolate, I can do candy, I can do it all. But I know someday, like when I have kids, this is going to be a really cool thing to do with them. Whip up some chocolate, whip up some ice cream. I'm going to be the dad that like shows up to the school parties. Oh, I made, all this fudge back here for you kids.
Oh, little Stevie Jr.'s dad showing up with the ice cream.
Exactly, exactly.
Sure.
So I'm looking forward to that. It's going to be, I think, a really exciting challenge. Uh, I know chocolate involves a lot of math, so going to need a bit of a learning curve on that, but it's going to be great. I'm looking forward to it. And it's something that I think is going to fulfill me in a way that, in a creative way. I think it's a great creative outlet for me. So, very much looking forward to that. How about
Very
you,
nice.
AJ? How's your week
Yeah,
been?
just rocking and rolling, man. I have a couple big papers coming up. One's due on Sunday, which I finished. I just got to do it, go read through, edit,
Nice.
cut, stuff like that. And then the other one is due next Sunday. What's April 1st? Is that Saturday or Sunday?
It's a Saturday.
Calendar's on Saturday. So I believe it's due Saturday night then. So that's my project for this week on top of all of the other readings I got to do. But that one's a fun one. That's my big paper for my writing class. So we have to do a motion and then we have to do an oral argument on the
Ooh,
motion. So my partner with the oral argument, his name is Zach, and it should be good. He's a good guy. It'll be a fun little debate that we got going there. So I'm excited for that too.
that is awesome. I I do want to talk about for one brief moment because you and I talked a lot about it off air last week. And I feel like it's an important thing to mention for the viewers of the show, just so they have an understanding of, a bit of a different dynamic because we come on here, we talk about issues. We just learned a little bit about, my little special skill set, confectionery stuff. AJ, law school, hustling, bustling, moving and grooving, writing papers, arguing in courts. You know what I mean? I think that we should peel back another layer of this, and I want to ask you a question. Why is Aaron Rodgers not a Jet yet?
Oh, that's a great question, Steve, actually. And it's because of your Green Bay Packers being a bit of a hard bargain. They think that the 39-year-old Aaron Rodgers, who granted is still a great football player, and I'm very happy that he's going to be our quarterback, is worthy of a first pick this year, a first round draft pick. And I don't think that that is a very fair argument. Maybe a second round pick and then a conditional first if we like make it to the Super Bowl, say next year. I think that that's fair compensation. But we don't even know if Aaron Rodgers is going to play more than 1 year. Why would we give up a first round pick for that? That all being said, that all being said, I think that the Jets have the leverage in this negotiation because I don't think the Packers want to pay Aaron Rodgers $60 million this year.
I would agree.
So, um, look, when the Jets got Brett Favre, it was like August 8th. It was late in the year. I think this will be cleaned up by draft time, which is in like 4 weeks now. So I'm not too
Okay.
worried. We have all the time in the world.
Very good. For those of you who don't know, and I know it's hard to see because I blur my background, but that little thing right there is a hanging Aaron Rodgers jersey that has had plenty of wear and tear on it over the years. I am a big fan of Mr. Rodgers and the Packers, AJ, and I would say it's almost generational for you, lifetime Jets fans over there.
Sure.
So this is news of Aaron Rodgers being traded to the Jets has sparked this incredible experiential dynamic in our relationship because now my quarterback gets to be a hometown quarterback and play for my best friend's favorite team of all time. And it's like the perfect meshing of two amazing things. A bit bittersweet for me because I do love the Packers. I do love to root for the Packers, but my
Purely sweet for
allegiance,
me.
yes, yes, my allegiance is to Green Bay. However, I can be a Jets fan for a season or two.
That's
So
fair.
I
That's
wouldn't be
fair.
the first Packer to be a Jets fan for a season or two. Let's put it that way.
Well, that's fair because I mean, when Brett Favre was there for a year, it wasn't I'm sure a lot of Packers fans were rooting for his success.
Yeah.
So, look, I don't think it'll be a Jets Packers Super Bowl. It'll probably be like a Jets maybe playing a team like, uh, I don't even know who's going to be good coming out of the NFC because now the Eagles lost everybody, but whoever the Jets play in the NFC, maybe like the Lions or something crazy like that
Oh yeah.
could even be. Um, then you root for the Jets, of course, but it's fine.
That's awesome.
Um, let's move on though. We have a tight show unfortunately
Yeah.
today just because we got a lot going on. But let's get into our first story, and our first story is going to be an interesting case that's making its way through the courts. It just went through the Ninth Circuit, which is just so you guys, for all of you that are not as just in depth legal knowledge, the federal court system is split up into a district court, a circuit court, and then it goes to the Supreme Court. So cases typically once they reach it to the federal courts, it goes district, circuit, and then Supreme. And then the Supreme Court has final say over everything. And this case went to the Ninth Circuit, which is mostly California and the West Coast. It's a particularly liberal circuit, and then there's other circuits that are more conservative, like I believe it's the Fifth Circuit, that's like Florida and that area, which is a more conservative circuit usually. Um, so this made its way through the Ninth Circuit, so out in California, and it's going its way to the Supreme Court. The Supreme Court, if you don't know, currently is held, the majority is conservative, so they typically won't agree with a circuit like the Ninth Circuit, and they'll overrule a lot of Ninth Circuit decisions. But we'll see if that's the case here, because once we get into the facts and we talk a little bit back and forth, I could see our court going either way on this. But Stephen, why don't we get into the facts of this case that I'm referencing? And yeah.
Yes. So I will say I know for the verbiage conservative is does the job. I just feel like it's an important notion that like justices on the Supreme Court are apolitical entities. So it's not like they are conservatives and liberals. It's more so like the premise of their ideology may favor conservative, things in practice, whereas people who tend to be liberal on the court, their ideologies tend to favor liberal practices. Tiny caveat, but I'm like a stickler on that because I hate politicizing an apolitical body.
Even though it's clearly not an apolitical body, but continue.
In theory,
In
and
theory, it is.
so we're recording this on Friday, March 24th. This case is going to be heard on the 27th, so Monday. So oral arguments haven't even happened for this case. And I think once we get those oral arguments, we can kind of dive back in maybe because I find that this is going to be a very interesting case that has decent implications for, as we're going to find out a lot of things. So the name of this case here, I want to make sure I don't butcher this gentleman's name, is United States v. Hansen. So I want to read from the facts and procedural history here that was put out by the Ninth Circuit. So you guys have an understanding of, like we said, the facts of this case, and then we'll go into the relevant language, statutes, and talk about what all this means. So hopefully when this decision gets read on Monday, well, the oral arguments happen on Monday, and we have a decision a few months down the line, we can kind of piece this together later in the year and almost see how accurate we were or what our understandings are. This is almost like a testing the waters type thing. But this is, like I said, from the Ninth Circuit's decision. So they talk about this gentleman. We're going to call him Hansen for his last name. And I'm going to read directly from the brief here. It says, quote, between at least October 2012 and September 2016, Hansen operated an organization called Americans Helping America Chamber of Commerce, AHA. AHA ran a program that purported to help undocumented immigrants become U.S. citizens through an adult adoption program. The program. Hansen falsely told victims that many immigrants had become U.S. citizens throughout the program. However, Hansen admitted to federal agents that no one had achieved U.S. citizenship through the program, and it is not possible to become a U.S. citizen through adult adoption. Counts 17 and 18, so they're referencing charges that were brought up against him, which he was ultimately charged for, found in a trial by jury, sentenced to 20 years for these acts, which we're going to get into. Were based on Hansen twice encouraging or inducing victims to overstay their visas. In spring 2017, a jury found Hansen guilty of 12 counts of mail fraud, 3 counts of wire fraud, and 2 counts of encouraging or inducing unlawful immigration for private financial gain. The trial lasted 11 days, and 37 witnesses testified. Witnesses included victims, former employees, investigators, and Hansen himself. At least 471 victims participated in the program, and each paid between $550 and $10,000. An FBI analyst testified that Hansen and AHA had more than $1.8 million in revenue. On November 9th, 2017, Hansen moved to dismiss the counts 17 and 18 on constitutional grounds. He argued that the statute, which is 1324A, Section 1, Subsection A, Subsection 4, I imagine is how I would read that, is facially overbroad, void for vagueness, and unconstitutional as applied to him. The district court, as AJ had explained the hierarchy, denied this motion. The district court sentenced him to 240 months for each of the mail and wire fraud counts, and 120 months each for each of the encouraging and unlawful immigration for private financial gain counts, all to be served concurrently. So, that is a mouthful. What to make of it? This man, Hansen, had a business and was promising illegal immigrants that if they paid him anywhere between $500 and $10,000, that he could get them through this program for adult adoption and make them become U.S. citizens. This was never true, has never been a way to gain U.S. citizenship. And in conducting this fraud scheme, Hansen had encouraged people to overstay their visas and stay in the country illegally for his personal private financial gain. That is the crux of what we're going to talk about today, is the legitimacy and I'll say the validity of a statute that prohibits exactly that. the kind of speech that Hansen had used and the implications for the speech, specifically the provision about private financial gain. So, AJ, anything on this to sort of peel back more before we talk about legal languagey type
Well,
things?
I want to just start with saying, like, when you talk about a case like this dealing with free speech, I think it's often that people don't really understand that while we have free speech in the country, there are limits on speech in our country. You can't just have out and out free speech and out and out chaos, right? Even though this isn't 100% true, the most common phrase, like, you can't yell fire in a crowded theater, unless, of course, there's a fire. Um, so you can't incite criminal activity. Like, that's not protected speech. It's well known that, like, solicitation of a crime, telling somebody to commit a crime, is not protected speech. It's a criminal offense. If I used this example earlier when it was just Stephen and I. If Stephen had a gun on him and we were in the store and I was like, Stephen, go rob the cashier, that's solicitation of a crime. Even if Stephen doesn't go do that, say Stephen was an undercover cop, he can arrest me for trying to solicit a crime or for soliciting a crime. Wasn't trying to, I did. Even though he didn't commit the crime. Like Stephen doesn't have to commit the crime for the solicitation to be a crime. So I think that should be understood first. Like, that's pretty well known and understood that in the criminal context, you can't solicit a crime.
Can I
Especially you
add?
can't just to use the terms one second. You can't just use terms. You can't knowingly or recklessly solicit a crime. If I think that you're if I if it's well established, like, maybe I really genuinely thought that Steven had a water gun and, like, I was joking around with him, you could probably get away with that. It was negligent, so it wasn't really the same, especially in these, like, knowingly and recklessly, which is the terms that are used here, and they have particular legal definitions.
So, I think a good way to think about it for me is I know, like a lot of American families, I grew up watching Cops, right? And I think the concept of solicitation is when you see those like prostitution busts where it's an undercover cop that they put out on a corner and like do the whole shtick. A guy picks him up and is like, "Hey, can I? I got $20 with your name on it." That's the crime right there. The solicitation.
Right, or like Chris Hansen is another good
Yes.
example of,
Yes.
like, soliciting a crime. Like, it's like these people are trying to get a minor to, you know, to have sex with a minor, or to get, like, photographs from a minor. Like, that's soliciting a crime also.
Yes. So, with regard to this case, the solicitation was he was encouraging these people to, or promising these people, and encouraging is the word, and they go into the definition of encouragement, meaning like to inspire, and not to clutter this discussion with semantics like that, but encouraging these immigrants to remain in the country illegally, so soliciting them to commit an illegal action, um, which, like we said, is the crux of the issue here. So,
Right. Well,
yeah,
it's that, along with the fact that, so the statute itself reads, you know, any person who encourages or induces an alien, which is the legal term for immigrant, to come to, enter, or reside in the United States, knowing or in reckless disregard of the fact that such coming to, entry, or residence is or will be in violation of the law. So the question is, can this person use their, basically say, hey, come stay, like, come stay with me, even if you're here illegally, you could stay with me. And then he goes on and he clearly commits fraud, like in the statement of facts
yeah,
that you said. But his argument is that him inviting them to stay is not is protected speech. And there's amicus briefs, which are basically people file briefs to the court to say, we agree with the respondent, or we agree with the petitioner, the person bringing the case, or the person responding to the appeal of the case, um, and back and forth. And they kind of try and influence the judges to give some background and sort of like an extra push in in just having the courts decide one way or the other. So there's a bunch of amicus briefs on the side of the respondent, who would be Hansen, saying that this is a violation of the First Amendment. One of them is from the organization FIRE, which is the Foundation for Individual Rights and Expression, and I think that they have a really good line talking about how this is an overbroad law and it really goes against, at its core, the idea of civil disobedience, which has a rich history in the United States, saying, reading from their amicus brief, expressing disagreement with the laws through advocacy of their violation, however, is part of a deeply rooted American tradition. And if the government may criminalize encouraging immigration law violations as a statute does on its face, so too may the government criminalize encouraging civil disobedience in other contexts, silencing an irreplaceable form of protest speech. The court should make it clear that the encouragement provision is overbroad, content-based, and viewpoint discriminatory regulations of speech that fails strict scrutiny. As such, it violates the First Amendment and therefore offers no viable blueprint for suppressing speech with which the government disagrees. And I think that that's a really strong point in favor of the respondent. But that being said, the government's argument in this case is basically like, look, he's committing a crime. And the language in the statute is clearly criminal language, like criminal intent language. And, and and if you are going to strike this down, that means all solicitation crimes are going to face First Amendment First Amendment challenges, and that will very, very, very much damper criminal prosecutions in cases like this. So I think that there's a clear balancing act that the court has to figure out here as to whether or not you have this right to encourage this type of activity, which some people say shouldn't be criminal activity at all, but it is, right? At this point, does the government have the right to go after this kind of speech? Is the fundamental question.
Yes. So I want to add, I think the Ninth Circuit, in their decision, which, again, for clarity, had overturned counts 17 and 18 of Hansen's conviction based on the section that we're talking about, right? They wrote, and this is to me the real meat and potatoes here is the plain language understanding of the subsection, right? So they say, quote, for example, the plain language of subsection 4 covers knowingly telling an undocumented immigrant, I encourage you to reside in the United States. Such a statement is protected by the First Amendment. See Williams. They reference this case Williams, which had upheld that the statement, I encourage you to obtain child pornography, is protected speech. So they're saying that the concepts of solicitation and how they function in the criminal matter are relevant in this case as applied to Williams. That's what the court used to ultimately make this decision on their opinion that this statute is overbroad and it does punish protected speech. And then they add on top of that Hansen and the people who submitted these other amicus briefs provide other examples of protected speech that, according to the plain text of the statute, is prosecutable. Things like encouraging undocumented immigrants to take shelter during natural disasters, advising undocumented immigrants about available social services, and telling a tourist that he or she may be unlikely to face serious consequences if they overstay their visa. So their argument is, well, if you prosecute me for saying this, based on the plain text of this language, if I was to just give it to anybody else and they read it as is, without a legal understanding, without understanding the meanings of these words, these things could also be punished. And I think that opens a dangerous door for things like immigration lawyers. The reality of the situation being there may come a time where it is appropriate to encourage an illegal immigrant to do something like take shelter. And I like you said, it's a balancing act. They're towing a very, very, very thin line because if this is punishable, and he was again, although fraudulently attempting to give these immigrants a pathway to U.S. citizenship, who's to say that anybody who does so legitimately, like an immigration lawyer, wouldn't be penalized for encouraging a similar thing?
I think that it's different there because the biggest point, and I understand because there's also the provision that says for personal financial gain, which you can argue a lawyer has. I think that first of all, there's like a different responsibility that a lawyer has in a case like this than a another citizen would have. Um, so I think that there's just a clear difference there in terms in like facts like the facts do matter in this case. The facts do matter in this case. I think too that the man is defrauding these people, right? I just first of all, this is not a very sympathetic defendant. I just want to put that out there, but
Agreed.
but while I can see these concerns, I think practically they're they are overbroad concerns in attacking the statute as overbroad. That being said, I could see the court going either way on this. I'm not 100%. I'm personally not 100% sold either way because I mean, fundamentally at my core, like I am naturally on the side of like protect speech at all cost. So it's like, yeah, I can understand not wanting people soliciting a crime, but like if like in a case like this, I I'd be more I wouldn't be upset if the free speech won the day, but I can understand to say, hold on, like free speech as we know it, like there's still limits here. There's still provisions around this. And one of those provisions is solicitation of a crime.
I agree with you, and I think the final piece that I want to mention before we wrap up is you had made an interesting point when we were talking about it earlier, saying that even if this provision is used as sort of a an add-on to an ongoing, you know, prosecutorial matter, which is how it was used in this case, I think I'm
And
okay
I'm
with
pretty
that.
sure that's how it's usually used. This statute.
Yes,
It's
yes. I just think, like you said, it's unfortunate now that there is sort of a microscope under this lens, and there is a degree of legitimacy to the claims that Hansen makes for saying, well, if you're going to prosecute me for this, then anybody who says any one of these other things, prima facie, should also be prosecuted if we're to take plain language as plain language and apply it to plain text. That's not how the legal system works. You and I both know that. And I think it makes a compelling argument to somebody who's not privy to the understandings of what exactly goes into a free speech argument, what the strict scrutiny means, and how we decide what speech is protected and not protected. So, in the capacity that it was used here, I think that it is well used as a tool to prosecute somebody who undeniably, like you said, a very unsympathetic defendant, somebody who did a bad thing, somebody who defrauded people of, I think the number was almost $1.8 million. They're not going to apply this. Not a prosecutor is not going to come knocking on your door if you say, "Hey, there's this really great program, out in New Jersey. It's a sanctuary state. Illegal immigrants. This is the kind of thing that favors you guys," and you're not going to get locked up for saying that. If you defraud people and you commit other crimes, it's sort of like a cherry on top to me. And I think in that capacity, I'm okay with it being used that way. I'm okay with speech sort of having that role in making a strong case against a criminal. Absolutely.
right. And I think that that's something that that's a case that the government's making here is that this is an ends test, not a means test. So it's like it's not we're not testing the means of what the statute is, but look at how the statute has been used. And that's how we understand it. And maybe if somebody uses this statute differently, a rogue prosecutor decides to prosecute this as more of a out and out kind of get him type of prosecuting, maybe you can make a better argument. But this is an ends statute, not a mean statute. So I don't know. We'll see. I think it's interesting. We'll see what the oral arguments are, and I mean, we won't have a decision on this case for months, probably like October. But we'll
Yeah.
when it drops, we should definitely revisit it.
Yeah. I like this. And I hope that this is a case that is digestible. And like we said, there are some serious implications. And I think free speech is exciting. I think, especially now in an era where we constantly find ourselves talking about things that are okay to say, not okay to say, both culturally, socially, and also legally, this will be a really interesting way to get a feel for the court in this new term. And I'm excited to hear about it. I think it's a great case and happy that we talked about it and happy that hopefully this information is landing on some really open ears that are also going to be just as excited as we are.
Yeah, absolutely. But we are out of time here, unfortunately, today. So we are going to have to wrap up. As all good things, this too must come to an end. So subscribe to Jersey First TV. Check us out. Get Bridging the Gap, the Nader Narrative, Real Talk with Fernando. Uh, Sign up for our newsletter over at jerseyfirst.org and sign our pledge over at jerseyfirst.org. And for Bridging the Gap and the Jersey First TV network, I'm AJ Malillo.
I'm Stephen Rambolo.
And we hope you guys have a wonderful week. Talk to you next week.